Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the Supreme Court judgment on black films used in cars. To discuss the issue, I have with me Mr. Atul Nanda, Senior Advocate, and Mr. Abhishek Goenka, Petitioner in the case. Now for the headlines. The Supreme Court prohibits use of any type of black films on vehicles. The court has directed the police to challan vehicles with black films and also remove films. And the court has threatened that non-compliance by administration may lead to contempt of court. The Supreme Court has prohibited the use of black films of any type on the windscreens and side glasses of vehicles. The court has directed the Home Secretary, Director General, Commissioner of Police of all states and union territories to ensure compliance. The order has been in operation from May this year.
The Supreme Court has ruled that the visibility level of windscreens and side windows of cars as provided by manufacturers cannot be increased or decreased by anyone. The court in its judgment observed that the use of black films gives immunity to the violators in committing a crime and considerably increasing criminal activities. At times, heinous crimes like dacoity, rape, murder and even terrorist acts are committed in or with the aid of vehicles having black films on car windows and screens.
A car or a vehicle with a tinted glass was like a closed room where nobody could enter. Even the police could not check at crossroads, and therefore the crime was absolutely on the increase, and that is when this PIL came before the Supreme Court.
A three-judge bench headed by former Chief Justice, Justice S.H. Kapadia, Justice A.K. Patnaik and Justice Swatantra Kumar prohibited use of any kind of black films on windscreens and side windows of cars. The judgment says use of black films prevents the traffic police from seeing the activity in the car. The number of fatal accidents of vehicles having black films is much higher in India than in other parts of the world. The court also reasoned that since the black-filmed vehicles have lower visibility, the chances of an accident increase by 18 to 38%. The court recorded that violators of permissible level of glass visibility has gone up from 110 in the year 2008 to 1,234 in the year 2010 in Delhi alone. The court directed that visual light transmission (VLT) with 70% for windscreens and 40% VLT for side windows are allowed, but it is the manufacturer who can provide for it. The court has exempted persons approved by government for security reasons.
We were not being able to regulate the breach of law which was happening because of tinted glasses. Means how will they monitor which glass is beyond 50%, which is beyond 30% and all that. So I proposed to the court that altogether this thing should be removed, because privacy is not about public places. Privacy is about private places.
Public-spirited citizens Abhishek Goenka had filed a public interest litigation in the Supreme Court. A petition had argued in favor of 100% visibility for windscreens and side glasses. But the court rejected his plea on the grounds that the parameters were already available in the Motor Vehicles Law. Rule 100 of the Motor Vehicles Act clearly states what kind of black glasses are to be used in the motor vehicles. The Supreme Court interpreted the same thing. With camera person Rajdeep, Subina Roy, Rajya Sabha TV.
The manufacturer of the vehicle may manufacture the vehicles with tinted glass, but no black film on or any other material can be pasted on the windscreens and side glasses of a vehicle. My question to you, Atul, is where do you see a contradiction, an issue in the entire scheme of judgment? Very, very conversant, in sync with most of the law of the land, but do you see any issues in the judgment?
See, at large judgment, till the time it says that a glass should be in conformity with rule 100, 70 for the windscreen and the back screen, and 50 for the side screens. There is absolutely no difficulty about it. But to my mind, the judgment requires to be reconsidered on an issue that the learned court has come to a conclusion that even if a glass is, say, 100% visible, to bring it down to 70% or 50%, nothing can be imposed. Where does the court get that from? If I see the judgment and if one reads paragraph 10, section 52 of the Motor Vehicle Act is quoted, where it is said that whatever is manufactured cannot be altered. If we read 52, 52 talks about registration certificate. Registration certificate, as we all know, is the chassis number, the engine number. It does not specify the color of the glasses. It may specify the color of the car. It may specify the make of the car. It may specify the model of the car. But it does not specify anything about the glasses. Therefore, to have a 100% ban on anything, any plastic material on the windscreen, which even if it conforms with section 100, is banned.
That is where you see a problem.
Now, please appreciate one thing. We are talking about...
Atul, the same plea was made and an interim application was made.
Yes.
And the same issue was raised. It was addressed by the court in the second judgment,
yes,
where it clearly dismissed any such logic and said, whatever is being given by the manufacturer is final, nothing over and above it. They were very, very clear of the point you were saying, anything that use of black or any other material, nothing doing, that is not happening. So, once even that has been settled, is there a point in going back to it again and again?
The issue is that the judgment must be in conformity with law. The court cannot add to a statute and can explain for sure. But I say if the rule says that the visibility should be 70% or 50%, if the glass is in conformity with that, I don't see a reason that there is any flouting of law or there is any breach of law.
Abhishek, you wanted 100% to be done away with. That means 100% transparency in the glasses. That was your plea. But the court did not accept that. Accepted what was mentioned in the Motor Vehicles Act. But there is a point that Atul is making, that if the car being manufactured is with 100% transparency from all sides, and if a consumer wants to bring it down to 70 and 40, what is wrong? What was the logic that the court gave in when this matter came before it?
See, you have to understand the idea behind the PIL. The idea behind the PIL is a very plain idea from an ordinary citizen. It's like any law cannot breach my fundamental rights. So my fundamental rights is right to life and right to live peacefully. So with the rising instances of crime and India being a resource deprived nation, wherein, like if you take the police numbers, is the lowest in the world per lakh of population. And mind it, I repeat, we are a resource constrained nation. So we cannot have freedom in terms of increasing the resources whenever we want to. So laws have to be citizen centric. They have to protect our interests. So we went to the court. We said that since the police, we had an exhaustive RTI applications received from various authorities.
It was well researched, yes.
Yeah.
The court appreciated it. In fact,
so we got the police numbers. We got the Luxometers numbers. It is surprising that in India, apart
we'll come to the Luxometer issue later on.
Yeah, so all the resources which are lacking were put forward to the court. The intensity of the crime was highlighted. You cannot point out a single crime where...
No, but the point that Atul wants you to address is that when it was brought before the court, the same issue that if the manufacturer is giving a car which is 100% transparent, and if the consumer wants to bring it, align it with what is mentioned in Motor Vehicles Act,
Yeah.
Section 100, which is 70/40. If the consumer wants to do that, then why can't the consumer do that?
Yeah, so the court went into the legislative intent behind the Rule 100 actually. They said that when it comes from the manufacturer's place, it comes as a colored glass. There is no film which is pasted outside the glass. So, color glass is by the virtue of some color mixing which is done at the manufacturer end
By the of the glass, okay.
of the glass. The vehicle manufacturer does not manufacture the glass. He buys it from the
And fits it.
and fits it.
Yeah.
Okay. So tomorrow, as a consumer, you want to bring your 100% VLT down to 70%.
You can't.
No, you can. You can go to a glass manufacturer.
Get it redone.
Yeah.
Okay,
and
that's
you
the
can
option.
always-
So now
that's
you
the-
already have an answer, which means if you really are so interested in bringing down the transparency level of your glass in conformity with the Motor Vehicles Act and bring it to 70/40, you take out the glass, go ask the manufacturer to design a new glass and fit it at the level of 70/40. What's wrong in
Designing
that?
does not
So
require.
what is the purpose achieved?
I mean, your transparency issues are sorted
No,
out.
I am sorry. Today,
Tell me
are
something.
we-
Why
are
do we need external films?
I am saying something else. Today, my learned friend is saying that you can go to a glass manufacturer and bring it down to 70%. Then why not have film? What is the purpose achieved? The effect of the same, effect of both are the same.
No, I understand. But why, if the sector, if the Supreme Court, due to security reasons,
Yes.
wants to completely keep the film industry away because it has security ramifications, then what's wrong in it?
I don't think Supreme Court wants a film industry to be away. Supreme Court
Not the film industry, as in the
I mean,
tinted film industry.
tinted film industry. What Supreme Court is saying,
Because of security reasons.
please ply your vehicle on 70 and 50.
Yeah.
If that 70 and 50 is achieved either by a film or, as my friend is suggesting, by replacement, where I don't see
The
any
Supreme
fallacy.
Court says ki, they have decoded the law, they have interpreted the law, and as per law, you cannot paste any external material on the glass.
That is clear.
That is
That they
clear.
have interpreted.
I am
No external
I
bill
am,
the-
I am asking which provision of the Motor Vehicle Act
says this.
says that there cannot be any imposition. Please appreciate one thing. Now, I have a, say, Maruti van. I put a guard. It is something external which has not come from the manufacturer. I put an additional guard. So, will that motor vehicle be also illegal? Should he be also challaned?
Maybe if
I get
someone
it.
puts a PIL on that, maybe Supreme
be
Court might
clarified.
come, it would be clarified.
Time for us to head into a break. When we come back, we will talk about the specific direction the court has made for the administration. Welcome back. The Supreme Court, in another judgment on the same issue, directed the police authorities not only to challan the offenders, but ensure that black or any other film pasted on the safety glasses are removed. The court also made it clear that police authorities found not acting may have to face charges of contempt of court.
The Apex Court, in an application seeking to review the judgment, not only reiterated its earlier judgment but also passed additional directions to the administration to act effectively.
The rule contemplates that the tinting of the glass has to be original, that is from the manufacturer. It is not permissible for anyone to affix film and tint the glasses, regardless of the fact whether such tinting of the glass by affixing film is within the permissible parameters of 70% and 50%.
The Apex Court directed all Director Generals of Police, Commissioners of Police to ensure complete compliance and not allow pasting of any material including film. The court directed the police not only challan the offenders but ensure that black or any other films or materials pasted on safety glasses are removed. It warned the police authorities that any complaint of non-compliance may lead to contempt of courts. It also instructed the copies of the direction to be sent to all concerned, including the chief secretaries of the states.
What the court has done is that a dead enactment has been activated, in the sense that police has been asked to enforce it by ensuring that tinted glasses are not used, or wherever it has been used, that film is removed.
Separate petitions by traders and manufacturers of black films were filed in Supreme Court after the court banned use of films on windscreens and side windows. The petitioners highlighted the positive impact of black films and pleaded that the court should review its orders, as it had done so without hearing their point of view in the matter, but the court rejected all such petitions. The Supreme Court judgment also stated that the number of violators of the Rule 100 of the Motor Vehicles Act had gone up from 100 in 2008 to around 1200 in 2010. With camera person Rajdeep, Subina Roy, Rajya Sabha TV.
A device called Luxometer can measure the level of opaqueness in windows owing to the application of black films. But this device is very scantily available with the police personnel in India. Your role as a petitioner now becomes very crucial, because the court in its second judgment has made it clear that anyone found violating will be pulled up for contempt of court. Now the court doesn't have eyes and ears, and since you are the petitioner, suddenly you are empowered, because now you will have to keep your eyes and ears open, and now you have a locus to go to court in case of non-implementation. Do you understand the responsibility of this?
See, my contempt petition is already pending in the court. Just because one or two review petitions have been filed, the contempt petition is delayed.
What is the contempt petition all about?
See, contempt is about bringing to notice the places where the implementation has not been done, and it also talks about appointing a retired judge of Supreme Court or any other authority which Supreme Court feels justified to monitor the implementation. Rather than booking the offenders, we have asked for a monitoring authority.
On the implementing part, do you really see an issue involved? Because now, I mean, Delhi it has started, but Delhi is not India. It is for India, the subcontinent of India. For example, in Cherrapunji, or it could be in Kanyakumari, or it could be in Kutch in Gujarat, or for that matter, Jammu. Do you think a uniform implementation of this thing has already started?
Well,
and is it possible?
I possibly cannot comment on it, but however I say, though I have reservations about a small portion of the judgment, this is the law of the land. It is the duty of every authority to implement
it.
Correct.
144.
But at the same time, we must respect the institutions. An institution has given a judgment. Who has the jurisdiction to give this judgment? It is not the duty of the state authorities, but also of every citizen to adhere to this judgment and follow this judgment. So therefore, my only comment on this is that yes, here is a judgment, we must bow down and we must implement this. And it is not, if anybody is offending, you don't have to wait for a police officer to take action. You as a citizen can take action, in the sense, bring it to the knowledge of the appropriate authority so that the action can be taken.
Now, which essentially means that the citizen at large has been empowered, including you. You have the biggest locus in the matter, and every citizen now can go to the court saying that I live in Panji and I have not, I mean, here the police administration is not implementing the tinted glass order, so they should be pulled in contempt. But you, how do you plan to monitor the entire activities to ensure that these directions, because you were the petitioner in the matter, that it is implemented in the whole of India, not only in Delhi?
See, monitoring, social media plays a very important part as far as monitoring is concerned. Like I am into the Facebook account of every, police authority, traffic police authority. So whatever major drives are being done, they are always updated on Facebook, and whatever major violations are happening, the empowered citizens keep on posting in Facebook. So this has become a very active tool, Then again, Google search is there. Whenever there is a strong police action, there is a lot of reaction which comes, both positive and negative. So you get it from Google that where the intensity is high as far as police action is concerned. So from that we derive the low intensity areas. Then we have our own team. They are initiating, like in Jammu and Kashmir, the content petition was initiated in High Court. Jodhpur, we had a big bash, international bash. All the guests were ferried in the black film cars, but the empowered group out there, they moved High Court and ensured that such things do not take place. So there's a team which is working who are based in different states. They are essentially lawyers, and on my communication, they move High Court as contempt of court instead of moving the Supreme Court.
Okay. And that is how you are ensuring that implementation happens from your end?
Yeah.
Okay. Time for us to enter into a break. When we return, we will show you an interview with Satyendra Garg, Joint Commissioner of Police, Traffic. Welcome back. My colleague Subina Roy spoke to Joint CP Traffic Police Delhi, Satyendra Garg, and tried to get his point of view on the issue.
The Motor Vehicle Act talks about the percentage of tinted glass that can be used in motor vehicles. Could you elaborate us on that?
See, the Act provisions are simple. Like it says that in the front and rear glasses, like the transparency level should be minimum 70%. That means tint can be only up to 30%. And on the side glasses, like window glasses, it can be 50% transparency and 50% tint. So this is what has been laid down. Now Supreme Court has interpreted it this way, that transparency means the inbuilt glass transparency, not the film. Because the reason is that film you can get in the market of any intensity, and there is no instrument available readily in India like which can exactly measure the transparency of the film.
The Motor Vehicle Act had already restrictions on the use of black films, and now the Supreme Court judgment which has upheld it. So what was the difference then and what is the difference now?
The difference, Motor Vehicle Act provision only mentioned about the transparency level, and said like okay, if somebody violates the law, like fine will be say 100 rupees. Okay, so before the Supreme Court intervention, like we were still prosecuting the people, but what used to happen is like people used to bear the fine, punishment, and still carried on with the violation. So what happened, like today you are caught, maybe after 3 days again you are caught, so again you pay the fine, but the remedial action, which is the removal of the film, was not happening. See, so after Supreme Court, the only difference that has come is on the spot, that offending film or violative film has to be removed on the spot.
The court in its order has said that use of these black films have been proved to be criminals' paradise and a social evil. This certainly helps the criminals to escape from the eyes of the police and aids in the commission of heinous crimes. The point you were trying to make relating to restriction leading to curtailing of lawlessness.
My point is, where do you stop? A kitchen knife can kill a person. So why don't we ban the use of kitchen knife? That's another question in an appropriate petition or case the court will have to consider. Restriction to what extent? The issue is that a citizen must live and let live in conformity with law. But where do you stop?
That is where we need to identify a point. The point you were making on the argument extended by the tinted film manufacturers, who went to the extent of saying that it protects skin cancer from happening, and an extended argument was made in the Supreme Court. What was
Not only argument, but the exhaustive supporting documents also forwarded as far as, like sun rays aiding skin cancer. But there was a very interesting defense which was forwarded on my part. See, India is a country which receives the strongest sun
UV
rays. Because equatorial region we fall in that. And we have more than 50% of the population into farming. And most of the population stays outdoors, majority. But in the whole world, we have the lowest incidence of skin cancers. And US, which has all regulations in place, the best, they have got the highest incidence, 9 times than India. So how do you prove the role of sun rays? And there's another study which says, without sun rays, you cannot have formation of vitamin D in your body.
That's true.
So
the entire argument was rejected by the Supreme Court.
Rejected, no?
Anyway, thank you, sir. Thank you. That's all the time we have. Thank you, sir, for joining us in this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.